Statutory Interpretation. This is an easy chapter, and it's tested in P2 every year. All you need to do is apply the given law in P2 and answer the questions. You only need to use the literal approach and know knowledge by yourself. It is just you and the law. Think like a layman who does not know any law and looking at the law for the first time ever. Take advantage of this chapter as it is very scoring. Introduction. As demonstrated at the start of this chapter, Parliament passes multiple laws yearly. The context of the legislation should be clear and precise in these laws, but that is not always the case. To help understand legislation, Parliament often provides separate sections to describe the terms used in that legislation. These sections are referred to as interpretation sections. Of example, in the 1968 Theft Act, the concept of theft is laid out in Section 1, and Sections 2 through 6 describe the key phrases in that definition. To help the judges understand basic words, Parliament has also enforced the Interpretation Act of 1978, which elucidates that he includes she's, and singular includes the plural unless the opposite happens. The interpretation of the law, in its broadest terms, is the method of assessing the meaning of a written document. The Interpretation Act 1978 has a limited scope to support judges with a statutory interpretation in that it contains the standard definitions of specific terms, including the rebuttable assumption that male-sex language often involves females and that the singular involves plural. There are three key principles for the understanding of a statute: the literal golden and mischief law, and also the holistic version, defined as the purposive approach. Each law will be discussed separately with case examples. 1. The need for statutory interpretation. Regardless of the aids listed above, many cases come to the courts because there is a conflict over the interpretation of an Act of Parliament. In such cases, the duty of the court is to determine the exact meaning of a specific word or statement. There are multiple reasons why the meaning may not be clear. These are the reasons why you will need statutory interpretation. A broad term. Words might be made to cover multiple possibilities. This can lead to problems about how wide this should go. There is a term in the Dangerous Dogs Act 1991, any dog of the type known as the Pit Bull Terrier, which sounds straightforward but has caused issues. What is the meaning of type here? Does that mean the same thing as breed? This was the key point in the controversy in Brock v. DPP, 1993, and the Queen's Bench Divisional Court determined that type had a bigger meaning than breed. This may include dogs which were not pedigree pit bull terriers but had a substantial number of dog features like that. Ambiguity. This is where a term has more than one meaning. It may not be clear what meaning is supposed to be used. A drafting error. The Parliamentary Council who drafted the original bill may well have made mistakes that Parliament has not found yet. It is highly likely to happen when the bill is amended many times before going through Parliament. New developments. New technology may surely mean that an old Parliamentary Act does not include modern-day circumstances. This is seen in the case of the Royal College of Nursing v. DHSS, 1981, where medical science and practices have progressed since the introduction of the Abortion Act in 1967. Changes in the use of language. Over the span of time, the meaning of words tends to change. That was one of the issues in the Cheeseman v. DPP, 1990, case. This case's Times Law report is set out in the activity section below. Police officers who encountered a man masturbating in a public restroom were not passengers according to Section 28 of the Town Police Clauses Act 1847 because, after several complaints, they were stationed in the lavatory. The Queen's Bench Divisional Court, therefore, held in allowing an appeal by way of a case reported by Ashley Frederick Cheeseman against his prosecution by Leicester City justices of a misdemeanor of deliberately and indecently revealing his person in a lane to the nuisance of passengers. Section 81 of the Public Health Amendment Act 1902 expanded the context, in Section 28, of the term street to include, inter alia, any place of the public resort within local authorities' control. Lord Justice Bingham, in accordance with Mr. Justice Waterhouse, said that the Oxford English Dictionary indicated that passenger had a meaning in 1847 when the Act was passed, now quite uncommon except in the expression foot passenger of a passerby or through a traveler, usually on foot, a wayfarer. Prior to the meaning of street being broadened in 1907, it was not difficult to apply the technical definition of passenger. It clearly covered anyone using the street for ordinary purposes of travel or transport. The dictionary definition could not be generalized too accurately to a place f public resort such as a public restroom, but when used in the sense of passenger, it had to mean someone resorting to a place in the usual manner for one of the reasons for which people would normally resort. The two police officers were not passengers if that was the correct approach. They were positioned in the public restroom to catch people who committed acts that had given rise to earlier complaints. The officers did not go there in an ordinary way, they moved to that place of the public resort but for a specific purpose, and were, therefore, not passengers.